Welcome to Loopholes and Lawsuits. I'm Jamie Schrabeck.
And I'm Mike Vo.
Hey there, Mike. Your backdrop looks a little different today.
Yeah, I am out in the field actually as we are recording this. I just got back from a press conference with Assemblymember Trita on AB 504 and would be more than happy to share what I know and what we can do as an industry to move things along. But before I do any sharing, let me do this. Let me do our standard disclaimers that we have on all of our episodes and our websites. The information and advice provided is not intended to be taken as and should not be construed as legal advice. No attorney client relationship is formed through any interaction with loopholes and lawsuits or any discussions on our podcast. You must consult with your own private attorney for issues that are specific to your situation. Further, all topics of discussion are based on the law in effect at the time of taping. Please make sure to check for later podcasts of loopholes and lawsuits for any changes in the law.
Mike, some of our viewers might be asking, what's AB 504? Because they aren't updated on what's happened during the session up to this point.
Let me go back just a little bit here. As many of you know, Jamie and I have talked ad nauseum about Labor Code 2778, the expiration of the exemption for licensed manicurists here in California, and how, as of January 1st of this year, all licensed manicurists are either going to be employees or owners, and how the courts look at their situation under the ABC test. So, in the last, 2, 3 months of this year, there's been a lot of confusion, a lot of frustration and anger about the expiration of the exemption. We were able to reach out to some of our elected officials, and Jamie and I, you and I have had the privilege of talking to Assembly Member Trita here in Southern California. And his office recently prepared and proposed a bill, Assembly Bill 504. Fairly easy bill to follow. All it does is it requests that the legislator remove the last subparagraph of Labor Code 2778, where it states that this exemption will not be applicable to licensed manicurists as of January 1st, 2025. The Assemblyman is looking to remove that last paragraph, which would then, in effect, allow licensed manicurists here in California to choose to work as an employee or as an independent contractor. So, with that said, I'm more than happy to share what went on this morning that could be a major change for the licensed manicurists here in California next year.
Our viewers, many of whom are here in California, were frustrated that something wasn't done sooner. But I want to reassure them with the new legislative session, this is happening as quickly as it possibly can. And the introduction of the bill is just the first step.
Right. That is just the first step. What we want to encourage all of our viewers and those who that are in the industry to contact their local elected official at the state level to be in support of AB 504. Because what's going to happen now is that the bill has been assigned to the Labor and Employment Committee. There will be a hearing in the committee on this particular bill, and there will be a vote taken in committee. So unless we can mobilize all of our nail professionals and to get them to contact their elected officials to be in support of AB 504, this bill may not make it out of committee. But even after committee, though, my understanding is that there may be a committee hearing sometime next month. But even after that, if it makes it out of committee, we still want to encourage all of our viewers and those who in the nail industry to continue supporting this bill. Have your elected officials support it, because it's got to then at some point be voted on by the entire legislature. We can't stop here. There's a lot of work to be done. And I know you and I, Jamie, we're doing everything we can in front of the cameras, behind the cameras, to drum up the support and mobilize votes that are needed.
Let's take a break for just a moment, Mike, and explain our roles, because those who know me know I am a licensed manicurist here in California. I am an establishment owner. I don't currently have employees, but I've had them for 17 years. I work solo now, and I will declare for everyone to hear, I do not get paid to advocate for the industry.
Right. Well, similar to you, Jamie, I'm a private attorney in my practice. I have clients across the spectrum in the beauty industry. The work that I'm doing with you on loopholes and lawsuits, or any work that I do outside of our podcast as it relates to the nail industry, is not income producing. I do not get paid for it. There's just no form of financial compensation to me. The only thing I'm getting out of it is that I want to see people have the opportunity to choose their career and the professions. And if they choose the nail industry, I would hope that they have the opportunity to choose whether to be an employee or an independent contractor. I'm a product of the nail industry. So the work that I'm doing here, it's all voluntary, non-income producing, and it's really just to help people be given that opportunity that my parents had.
That's another reason why you won't see us asking for money.
Oh, absolutely not. No, there is no money contribution through loopholes and lawsuits. The only time we're going to get money is in our day jobs, right? Me as a practicing attorney or Jamie providing no services. That's the only financial or any type of compensation that we're getting out of this.
I wanted to say that to make that clear to anyone who might not understand the role of different organizations, different individuals in the legislative process. When we've talked about why hasn't there been a lawsuit, that issue of standing, and we need someone, if someone were to file a lawsuit, someone would need to have been harmed.
Right. So one avenue of accomplishing change in the law is through lawsuits, but as you've already stated, there has to be a plaintiff, someone who's been aggrieved by the law, right? You and I, Jamie, we have our opinions on the law, but we promote compliance. And I still promote compliance, even though I disagree with the law. I still advocate for compliance. But if any of our viewers out there who say, hey, you know what, Mike, I am aggrieved by this law. I've been singled out. I have other friends who are other type of licensees and they don't have the same restrictions, but I do. And I just don't believe it's fair to me. I think it's maybe illegal and lawful in terms of the treatment that I'm subjected to, the restrictions I'm subjected to. I'd love to talk to you and see if this is something that is worth pursuing to advocate for a change in the law. I want to be careful. When I say for advocate for change in the law, it's not because we're doing it through certain organizations. I'm advocating for a change in law through my private practice as an attorney, not through a nonprofit organization or anything like that.
And then there are lobbyists whose role, and many of them happen to be attorneys, whose role is to work on behalf of a client, usually an organization that's paying them to lobby those assembly members and senators to vote a particular way on a bill.
Right. They're paid people. Those lobbyists are paid people. Our legislator is a paid legislator. They get compensation for their work, which is great. I mean, everybody can't work for free. We got to pay the bills too. We're blessed to have day jobs that pay for our bills, but allows us the flexibility to raise awareness of the issues and the challenges in the industry. We're happy to share our knowledge and our experience to keep our fellow colleagues out of trouble.
Speaking of raising awareness, Mike, let's talk about the class we had. It was our first ever Loopholes and Lawsuits class at Premier Anaheim. We had submitted a subject that we thought would get people's attention. The title of the class was Booth Rent Isn't Legal, Nobody Told Me. And we had this bill to discuss, which wasn't the case when we first submitted the class to Premier.
I think we submitted the class agenda sometime back fall of last year. So AB 504 was not even in existence. The educational aspects of the expiration of this exemption was something that I was starting to raise awareness to. So we were blessed that fast forward 6 months, we're at Premier Anaheim. We had this bill. We had the district director from Assemblyman Ta's office to come in to share what they've been doing to discuss the law that's been proposed. So it's exciting. It's exciting that we can be a part of this change. And great when Colin, the district director, said at the end of last year, it was Assemblyman Ta's office that reached out to us for input as to this AB 504.
We've recorded that entire class, and it doesn't have the sound quality or the video quality that we would come to expect from our normal podcasts, but we have posted that to our website and to YouTube. So I'll put a link to that in the show notes.
Awesome. Yeah. If you haven't, folks, if you haven't watched it, it's a good short 45, 50 minutes. I think it was. The rest of the time we were answering Q&A. There was a lot of good material. We had also there in the room was Chris Underwood, the executive officer of the Board of Cosmetology. We also had Myra, the regulatory affairs director from the PBA. So that speaks volume as to their support for what we're doing with 2L and the educational component of our work here.
For those of you unfamiliar, 2Ls are shorthand for loopholes and lawsuits.
Forgot about that, yes.
Oh my goodness, all of our secrets released. So that timeline, the introduction of the bill, the assignment to committee. In the meanwhile, we had our loopholes and lawsuits class. Now we are moving forward with more awareness with Assemblyman Trita's office hosting a press conference, and he himself was there.
Yes. He was there to announce not just the submission of his bill, but his office, which represents a large portion of the Little Saigon community here in Southern California. His office is requesting an investigation at the Department of Justice to look into race discrimination, the effects, the disparate impact effects of the law as it relates to Vietnamese American licensed manicurists. So Treetop takes this very seriously, not just submitting the bill, but he wants to have the federal government look at the constitutionality of the current Labor Code 2778 and its impact upon a certain portion of the licensed manicurist community.
Give us a little background on your role at the press conference. I know that you attended. Did you expect to speak?
No, I was not. I was just expecting to show up and to lend my support in favor of AB 504, as well as supporting his efforts to have the Department of Justice look into the disparate treatment or impact, I should say, of the law. I was notified there at the press conference that I would be standing up behind him or next to him and also speaking, saying a few words about the law and its impact. So I kept it short, was very focused on the law, labor code. I know that there were two other beauty college owners there that were in support, as well as other local elected officials who also expressed their support for the bill as well.
The support is so important. And you mentioned previously that Christy Underwood, Executive Officer of California's Board of Barbering and Cosmetology, was at our class, as was Myra Reddy, the Director of Government Affairs for the Professional Beauty Association. And Trita announced the support of the board for the bill.
Yes, I didn't know what he knew or didn't know, but he did publicly share at the press conference that the board has and will support AB 504, which is huge. And Jamie, maybe you can speak into it more because I don't work too much with the board on legislative issues. Was this something very unusual for the board?
The board last fall took an unusual step in approving a policy statement. And typically, the board, through the course of the year and through the course of a legislative session, would evaluate bills that impact the industry and would take a position. And the position could be support, it could be oppose, it could be we're just going to watch this. And there was no bill to take a position on come last November. But through the years, the board has expressed its opinion through its various members and collectively that they think that all license types under the Board of Barbering and Cosmetology should be treated equally. So this was the policy statement they put out in November. They approved this policy. So it gave a signal to any assembly person or any senator that if they were to introduce a bill that would help get us closer to equity among the license types, that the board would be supportive. The news that's being shared now is that the board will be sponsoring the bill, which is even more important because that means the board has a vested interest in having this pass.
Right. No, that's great that they're going to sponsor the bill. I can see how it's very unusual for the agency to take a position on this, but I'm glad they are. And I'm glad that they see that this is an issue of equal treatment amongst all licensees. Why should the nail industry be singled out and not esthetician, cosmetologist, barbering? I think it's only the right and fair thing to do is to treat all licensees equal. Now, I know that for some of you who are viewing this, maybe thinking, well, Mike, isn't this more an issue of protection of certain industries? The laws that are already in the book, the current Labor Code 2770, that law, if implemented and enforced properly, would continue to protect all licensees. There's a total of six subparagraphs. The sixth one talking about the expiration for nail manicures, but the first five that talks about the terms of engagement. Well, assuming that a licensed manicurist is following all five criterias or requirements, he or she would be properly classified as an independent contractor. Now, if he or she doesn't meet those five criteria, then you're right. They've been misclassified and should have been an employee. So the issue here is that the law just needs to be implemented and enforced routinely and equally. By removing the exemption for manicurists, it doesn't quote unquote protect them anymore. It doesn't do that because compliance with the first five subparagraphs of 2778 would have done that in the first place.
That's what I liked about that language in AB5 when it passed, because as we've talked in previous episodes, and we went into much more detail then, it laid it out pretty clearly how it's supposed to work and how you can be compliant and be an independent contractor. Regrettably, and it continues to this day, in our industry, we use very sloppy language to describe the arrangement. We use terms like booth renter, suite owner. I could just rattle off a whole bunch of terms that don't apply when it comes to what is it that you're actually doing when it's judged by the Internal Revenue Service, when it's judged by the Board of Barbering and Cosmetology. Are you an establishment owner, or are you someone who works in the establishment? Are you an independent contractor, or are you an employee? Are you self-employed? I mean, we could just go on and on. And so as we're trying to get people on the same page, this has been one of the struggles that we've had in sharing information, is that we're not always talking about the same topics. We may be talking about the same topic, but we're not using the same terminology, and it gets very confusing. We've acknowledged that before. We're trying to clear it up. But what I don't want us to do going forward, as we're trying to get this bill passed, is to get bogged down in our differences, our explanations, our situations. Bottom line is we want this bill passed, and we need everyone's help in getting it done.
Right. This is not a partisan issue. It's not an employee versus owner issue. It's every licensee. If you hold a California manicuring license, this affects you. Now, if you choose to be an employee, that's great. You exercise the option to be an employee. We want to make sure that if you choose and want to exercise to be an independent contractor, that you have that option. As of right now, you do not. Right? That's really what it's about. And you're right, Jamie. You're talking about different terminologies. I've hosted many in-person seminars when I'm asking folks, independent contractor, an employee, W-2, 1099. Now, I know for a lot of folks that can get confusing, right? And it was. But I'm hoping that on a forward going basis, as an industry as a whole, that we start harmonizing the language, that people understand 1099 is a tax status with the IRS. You're not going to go to the labor code and find 1099. It doesn't exist. It's independent contract. So I want to make sure that we have our viewers, especially, to understand the different terminology and to use it appropriately. Let me just share this really quickly. When people talk about we need to protect employees or manicurists, looking at a particular segment, in particular the Vietnamese American, I represent a fair amount. And if you're hearing the 60-40 split, or where the salon owner issues a 1099 to the manicurist at year's end, all of that was never legal in the first place. It is illegal. Okay. I'm not trying to support that, condone that. It's always been illegal. But I think what's happening is that there is a misapplication of certain industry members to the broader industry as a whole. And I think that's very unfair. For those who were doing it improperly, 60-40, I give you 1099 a year, you were never compliant. Under any law, you were never compliant. Okay, let's just be very clear on that. And I know for some of you watch, say, well, Mike, what about that segment? Yes, they're doing it wrong. I've never condoned that. Let's set those folks aside. For those who want to be compliant, who are doing the right thing, doing the good thing, we want to make sure they have that option to continue in their choice as an independent contractor.
Mike, let's talk about how we plan to keep people updated about the progress of this bill and what they can do right now to help it get that committee hearing.
Well, right now is contact your local elected official, state elected official, tell them who you are, maybe if you're an independent or employee, and how that affects you, the law, and that you're in support of AB 504, and you want to encourage them to vote in favor of AB 504. So that's what we would encourage our viewers to do. We also have heard word that the Pro Beauty Association, to make this process a little easier, they're going to be sending out an email notice about their support and kind of streamlining the process to write to your local elected official in support of AB 504.
Yes, and you don't have to be a member of the Professional Beauty Association to take advantage of this. In fact, anyone can use this toolkit when they get this together and launch their campaign. You can have your clients do it, your friends, your family. They can use that link to find their representative. It'll do it for you automatically. It will have a draft statement that you can personalize if you choose, but you don't have to. And then it will get delivered directly to the legislator who needs to see it.
Perfect. That's really easy. And then, in terms of what you and I are doing here, on loopholes and lawsuits. We're going to continue to work with Assemblymember Trita's office as this thing works this way through the committee. If we're asked to testify or publicly support the bill in committee, I'm more than happy to take a position on it and testify. After that, in terms of what we're going to do, we'll keep everyone posted on our loopholes and lawsuits social media channels, and we'll host future episodes as soon as we hear something to kind of keep our viewers updated on where this process is.
Thank you, Mike, for all your hard work.
No, thank you, Jamie. I know that you and I have daytime jobs, but this is near and dear to us, and we're happy to see that members of our state elected office is taking this seriously and going to make some changes, and hopefully that will go into effect come January of 2026.
If you want to stay informed about this bill or any of the other topics that we would like to cover in the future when we have more time, please follow us on Facebook, and you can go to our website at loopholesandlawsuits.com. You can sign up for our email list. And again, if you want to share your experience with loopholes and lawsuits, we encourage you to promote us because we can only do so much, and we could use your help in getting the word out.
Yes, absolutely. Help us help you, right? We want to help you get the word out, let people know. Let's get the law changed. And then once we're beyond this legal issue, would be happy to continue to discuss all things beauty, whether nails, hair, anything involving the beauty industry. I think it'd be fun to talk about other topics other than the legal stuff all the time.
But as we know, Mike, the legal stuff gets to be legal stuff through the legislative process. So we are living an example of advocacy in action.
Yes, yes, we definitely are.
We're trying to lead by example.
Yes, no one can say that Jamie and Mike aren't showing good leadership skills and walking people through. I mean, we really want to walk you through this process so that we reduce the amount of independent research that you have to do. But as we always say, don't take our word for it. Do your own homework.
There will be lots of show links for this one.
All right. Well, hey, thank you everyone for joining us on this episode of Loopholes and Lawsuits. We'll keep you posted either on the next episode or check us out on our social media for the latest updates.